Exceptions to strict liability. Although the rule of strict liability, as laid down in Rylands v. Fletcher, is very strict, the law recognizes certain exceptions where the defendant will not be held liable, even if damage is caused. The main exceptions are explained below in simple, exam-oriented language. Act of God. Case law, Nichols v. Marsland. Facts. The defendant constructed artificial lakes on her land. Due to extraordinarily heavy rainfall, which was unprecedented in nature, the lakes overflowed. The water escaped and damaged the plaintiff's bridges situated on adjoining land. The defendant had taken reasonable care, and the event occurred solely because of natural forces beyond human control. Held, the defendant was not liable. The court held that the damage was caused by an act of God, which was unforeseeable and irresistible. Since no human skill or precaution could have prevented the accident, strict liability did not apply. Act of a third party. Case law, Rickards v. Lothian. Facts. A stranger deliberately blocked waste pipes in the defendant's building and turned on the taps. As a result, water overflowed and damaged the plaintiff's shop below. The defendant had no control over the third party and had not acted negligently. Held, the defendant was not liable. The court held that the escape of water was due to the independent act of a third party, and therefore the rule of strict liability was not applicable. Plaintiff's own fault. Case law, Ponting v. Noakes. Facts. The plaintiff's horse entered the defendant's land and ate poisonous leaves from a tree. The leaves were entirely within the defendant's boundary and had not escaped. The horse suffered injury due to its own intrusion onto the defendant's land. Held, the defendant was not liable. The court held that the injury occurred due to the plaintiff's own fault, and there was no escape of a dangerous thing. Hence, strict liability did not arise. Consent of the plaintiff, valenti non fit injuria. Case law, Carstairs v. Taylor. Facts. The plaintiff occupied the lower floor of a building while the defendant occupied the upper floor. Water stored in the upper floor leaked and damaged the plaintiff's goods. The arrangement was for the mutual benefit of both parties, and the plaintiff had impliedly consented to such use. Held, the defendant was not liable. The court held that the plaintiff had impliedly consented to the risk, and therefore the defense of consent applied, excluding strict liability. Statutory authority. Case law, Green v. Chelsea Waterworks Co. Facts. The defendant water company was authorized by statute to supply water. A water main burst without any negligence on the part of the company, flooding the plaintiff's premises and causing damage. Held, the defendant was not liable. The court held that when an act is done under statutory authority and without negligence, strict liability does not apply. Natural use of land. Case law, Rylands v. Fletcher. Facts. The defendant constructed a reservoir on his land for industrial purposes. Due to hidden defects in the soil, water escaped and flooded the plaintiff's mine. The storage of a large quantity of water was considered unusual for the land. Held, the court held the defendant liable, explaining that strict liability applies only when there is non-natural use of land. By implication, if the use had been natural, the defendant would not have been liable.